qualifications in law and computer science. Simon also has a special interest in AI and leads the firm's working group on AI. He is a member of the firm's National Cybersecurity Board. Simon will be in conversation with Professor Matthew Sagg, who is a Professor of Law in Artificial Intelligence, Machine Learning and Data Science at Emory University Law School. Professor Sagg is a leading US authority on the fair use doctrine in copyright law and its implications for researchers in the fields of text data mining, machine learning and AI. Professor Sagg was born and educated in Australia. He earned honours in law at the Australian National University and clerked for Justice Paul Finn at the Australian Federal Court. Professor Sagg practiced law in London as an associate at Arnold and Porter and in Silicon Valley with Skadden Arps, Slate, Meagher and Flom. In July 2023, he testified to the US Senate Judiciary Subcommittee on Intellectual Property in relation to copyright and generative AI. The purpose of this evening is to facilitate a conversation between Simon, Matthew, and yourselves. While the keynote will be recorded, we will then be moving to Chatham House rules and would encourage you to ask questions and engage in debate on this issue, which no doubt will continue to impact the way we work for years to come. I would like to now welcome Simon and Matthew.
Well, thank you very much for that kind introduction. Thank you all for turning up here today. My voice is a little bit shaky from having been talking all day, and I am severely jet lagged, but I will do my best to be brief and coherent. So what I want to talk to you today about is really understanding the role of copyright in generative AI. There's a lot of discussion that you will have heard, some of you will have been part of that discussion, about how generative AI models ingest copyrighted works. And I want to, if you take one thing from this keynote, I hope it's that ingestion is a terrible word, right? It has no legal or technical meaning. To the extent that it means anything, it is inherently misleading. And I'd like to sort of walk you through that. So I have a little diagram here that takes you through the life cycle of either a text data mining project or a machine learning, artificial intelligence, generative AI project. You start this project by getting access to the data. If it's physical books, then you buy copies of the books. If it's works on the internet, then you get access to that. This raises potentially all sorts of issues around contract law, around digital rights management, or I think you call them technological protection measures here. But at this stage, we're not actually talking about copying. The copying is what comes next, right? It is technically possible that you could train an AI model without a locally stored copy of the training data. But I will tell you that no one I have talked to in Silicon Valley does this, right? It's just not feasible or practical. So if you take a model like GPT-3 or GPT-4 or GPT-5, which is coming, we're told, the training data is sitting on a server, probably somewhere in Mountain View, California, because before you begin training, you need to analyze the training data. You need to filter out the toxic material. You need to deduplicate the training data as best as you are able. And there are probably a few other steps that you're going to take as well. So there is no doubt that today's generative AI models are built on massive amounts of copying. We're not talking hundreds, thousands. We're talking in the hundreds of millions. Interestingly, that is kind of, if you do it right, that is the beginning and end of the copyright relevant activities in machine learning training. the actual process of training a model, or the kind of analysis that you would do in text data mining that doesn't involve machine learning, doesn't involve making a copy of the training data. And the use of the model, again, if you've trained the model correctly, doesn't involve making copies of the training data. There are three reasons for this that I would like to share with you. The first is just simply copyrighted training materials are not copied into the model. I'm going to explain this in more detail in a minute. Secondly, when these models learn, which is a metaphor, granted, they're learning at quite an abstract level. And finally, at the point of inference, at the point of output, the models are combining the abstractions that they've learned and generating things that are genuinely novel. So this idea that Stable Diffusion or DALL-E 2 are just like a cut and paste or a collage of previous material is in most cases fundamentally false. So what is a large language model? A large language model is not a thinking machine. Right? A large language model is a model that was trained to predict the next word or the next token. We may as well just talk about words. When the model guesses what the next word is more correctly, the attributes of the model that led it to that guess are effectively upvoted. And when it guesses poorly, those weights that made it guess poorly are downvoted. You do that with enough data, with enough rounds of training, you get a model that is surprisingly effective. To understand this a little bit more concretely, would anyone like to complete this phrase? Hair. Not propeller, semicolon, harmonica. Right? Why did you say hair? Where did you read that?
In communications, in discussions.
Yeah. My point is, and Lucinda's being very sporting here, if you guessed hair, which every time I give a version of this talk someone does because it makes sense, it's because of the things that you have learned in your whole life about English language and English grammar and English syntax. It's also because of all this cultural knowledge that you have learned about the things that we choose to observe in writing about girls, right? There's a whole English lit dissertation to be written about this. You didn't guess light, because that doesn't make any sense. You didn't guess harmonica or semicolon or propeller. But my point is, when you guess hair, it's not because you copied it from having read it once. It's because in your mind, there's a very sophisticated mental model. And that is exactly the way ChatGPT works. Now, I don't want to suggest that large language models learn in the same way that people learn. And the metaphor between a neural network and what's going on in our brains is quite overcooked. But if we're choosing between the metaphor of the language model learning like a student or copying like a scribe in a monastery, well, it's clearly the former. So that's point number one, is that the process of training is not copying. The copying takes place earlier. Point number two, I've just realized my mic should probably be on. Point number two is that when these models learn, they learn in a very abstract way. So what you'll see here on the left is several examples from the Stable Diffusion training data. Stable Diffusion is a text-to-image model. These images all have the words coffee cup associated with them. On the right, you will see my creation, which is a coffee cup that is also a portal to another dimension. Stable Diffusion has learnt something about coffee cups. It has learned, although it doesn't understand anything about the taste or smell or concept of coffee, but it has learnt that coffee cups look kind of white and round and ceramic and have small handles and have a sort of blacky brown liquid in them. But it has abstracted away the women with smooth skin, the men with facial hair, the hats, the sunsets, the ocean views, the cookies, the weird alien creatures, whatever that thing is. Is that a Pokemon? Yeah. That's a Pokemon. Right. All that has been abstracted away, and the model has learned a latent construct of what a coffee cup is. Critically, it's learned a latent and uncopyrightable abstraction of the features of a coffee cup. My third point is that, and let's stick with the text-to-image models as an example, at the point of inference, when you prompt a model saying, do this, you're usually combining these latent concepts into something genuinely novel. And by novel, I mean novel in the patent law sense, of something that didn't exist before. So when I asked Midjourney for a teddy bear in rich, opulent clothing with a hypnotic stare reading a newspaper, yes, it drew on a kind of latent concept for all of those things individually that is nested within the larger model. But man, what it produced is something really different, right? This would not exist but for the training data, that's clear, right? Without the training data, you just have a bunch of random weights and it's nonsense. But this is not in the training data. This is a new thing. And it's also surprising in that my bear does not have a hypnotic stare. My bear has sunglasses, but kind of an attitude. Like, these points are important to the copyright law analysis because there is, undeniably a ton of copying that takes place to make all this happen. It takes place before the training. The models themselves, if you do it properly, and I'll come back to this in a minute, are not copies of the training data. And the things the model produces are not copies of the training data. Under American law, this is what we would call a non-expressive use. You don't have a fair use doctrine in Australia. You have fair dealing for specific purposes. Our law started where your law started, with fair dealing in the United Kingdom. But we went off in a different direction, a more open direction. And so in America, you don't need to have a statutory, pre-approved use that is fair. You just need a use that is fair. Classic fair uses are like commentary, criticism, parody, etc. But we have had in the US a sequence of cases where, as part of a technological process, copyrighted works have been copied, analyzed, and then metadata has been derived from those works. The earliest of these cases are about software reverse engineering. To pull out the APIs from object code, you have to make a lot of intermediate copies. But the final products that were produced contained none of the original expression, and the court said that's fair use. In a case involving plagiarism detection software, student term papers are copyrightable. They were the inputs. The output is simply a piece of analysis that says this paper is or is not like this other paper. That external observation, it undermines the market for plagiarism, but it doesn't undermine any recognized copyright interests. In the Hathi Trust and the Google Book cases, you had 20 million library books copied. In Hathi Trust, the issue was text data mining. And in that case, the court said, wow, this is really interesting. We've never had a case like this, and yet this is quintessentially transformative use because none of the original expression is being communicated to a new audience. Right? And that is what I mean when I talk about non-expressive use. And then in the Google Books case, well, it's kind of the same case as Hathi Trust, except with the issue of, are these snippets too big on the back end? I assume most people who used Google Books are at least vaguely familiar with it. These non-expressive use cases indicate very strongly that by and large, using copyrighted works as training data for machine learning should be fair use. Now, generative AI is slightly different in a couple of respects. One respect is that you're not just producing derived metadata, you're producing new copyrighted works. But the point is that they are new copyrighted works. They're not the original expression that was in the training data. And so that is probably mostly a distinction without a difference. The other thing that is different about generative AI is, I know I just told you that they don't copy. Sometimes they do, right? Sometimes generative AI models overfit. They accidentally learn far more specifically from the training data than they are intended to. Turns out mostly this is a problem of not deduplicating the training data well enough. Sometimes it's because images are associated with tags that are too specific. This is an example. The tags that go with this image are like a whole paragraph of text. So if you put that paragraph of text into Stable Diffusion, you get this image or something like it coming out. That's really unusual, but it does happen. Another issue is what I call the Snoopy problem. The Snoopy problem is that there are some copyrighted works that we actually protect at a much higher level of abstraction. And in particular, at least in the United States, copyrightable characters we protect at a much higher level of abstraction. I'm pretty confident that you all know how to draw a picture of Snoopy. Well, Stable Diffusion and Midjourney know that too. They have learnt Snoopy just in the same way that they have learnt how to draw a banana or an aeroplane or a motor car. Right? You can't solve this through deduplication because the Snoopy images in the training data aren't duplicates. They're just consistent in their Snoopy attributes, just like the coffee cup, and they're all labeled with Snoopy, which is a word that doesn't appear in any other context. So all the image models, unless you filter out the word Snoopy, are going to learn how to draw Snoopy, and that potentially is a copyright problem. Also, your standard LLM knows a lot about your favorite books and can help you write an infringing sequel. So I don't know if you've read Saturday by Ian McEwan. There are enough reviews and summaries of this book out there on the internet that GPT-4 does an excellent summary, had some really neat ideas for what a sequel might look like, and was quite happy to help me begin to write this clearly infringing and kind of silly sequel, right? So works that we protect very abstractly can be infringed by generative AI. Also, as the Sunday example shows, in the hands of a determined user who has some knowledge of the copyright at work, an LLM can be a tool of infringement. But there's a reason I have a little icon of a typewriter at the bottom of this slide. It's because that description applies to a typewriter as well. So one of the tricky questions with generative AI is going to be allocating responsibility between the people who created the model, the people who are operating the model, and the people who are using the model and telling it what to do. And that is an issue that I don't think there is any single answer to, because the facts and the relative weights of those are going to vary from situation to situation. There is a lot more to talk about in terms of copyright and generative AI, but I think that's a good place to get the discussion started. So thank you.
About a few things ourselves and then sort of invite the floor. Can we start by talking about all the cases that are going on? There's really been a bit of a tsunami of cases this year, I guess, in quite a number of different industries. How many cases are there? What's your view about them? And are there, is there any cases that are more important than others?
Yeah, so there are 11 different cases that I'm tracking at the moment. It's hard to appreciate the significance of these cases without a little bit of an understanding of sort of American class action law. 11 cases sounds like a lot. When you read these complaints, it's like, oh my goodness, there's this cause of action, there's that cause of action, etc. Some things you should know. One, many of these class actions are filed by the same law firm. Many of them are like literal Xeroxes of their other class actions, just with different plaintiffs and different illustrations. Most of the claims are either nonsense and or will be preempted by federal copyright. So there are some crazy California unfair competition and weird negligence theories that I honestly don't even understand. That's all nonsense. That's all going to go. These cases, they kind of attack the copyright question, some of them in slightly different ways. And there are some privacy complaints that might actually have some merit to them, because we don't have a lot of privacy law in the US, but California now has sort of decent privacy legislation, and depending on how that new legislation is interpreted, there might be some issues there. Potentially the most important case is Getty Images versus Stability AI. It's the only one that's not a class action. Getty Images owns the rights or controls the rights to an enormous amount of commercial photography, not just stock photography, but sort of high-value images of celebrities and famous artists and sporting events, etc. Getty also has a trademark complaint that is an absolute winner, because Stable Diffusion randomly produces images with the Getty watermark. Does seem like a trademark problem. Disappointingly, I'm worried the trademark claim is so good that Stability AI will have to settle that case, and we'll never get to the fun copyright issues. But I think that is the key case to watch. But all of these cases are in their very early stages. Like, you have complaints, you have like one motion to dismiss, but the defendants haven't answered. And I'm trying to remember my Australian Civ Pro, but basically the defendants haven't even said what their defences will be and which facts they agree to, which will be none of them, because that's the way Americans litigate. Most of the claims will be tossed out, but the basic copyright question of you copied all this stuff before training without our permission, that will survive summary judgment. That will get at least as far, sorry, that will survive a motion to dismiss. That will get at least as far as summary judgment. It could be handled on summary judgment, or it might not be. But in the meantime, because these are class action cases, the class needs to be certified. And in Google Book, that took like 6 years for the court to decide, yeah, this class is not going to get certified. So there are a lot of lawsuits. I wouldn't expect much law for a long time.
You have to wonder whether, this is just the tip of the iceberg that, we've got in those cases, I think, software, artwork, photographs and books. There's many major industries that aren't represented that are massively affected by this. There's some, very well-resolved plaintiffs that are no doubt watching it carefully. So if you can sort of broaden the question out a little bit and say, let's steelman the case for the plaintiff, the, general plaintiff here. So if you were, running the best argument for them, how are they going to win the copyright case? What's their best point?
One argument that a plaintiff could make is that, all these non-expressive use cases, they're actually all incredibly fact-specific. There's no general pattern there. There's no theory there. And I guess that's something you could argue. I don't think that's very persuasive. I think that these precedents are fairly well established. They make a lot of sense, and they're likely to be upheld. I think that you could distinguish HathiTrust and Google Books by saying, okay, maybe a non-expressive use is good under factor one, maybe it's equivalent to a highly transformative use, which is what all the cases say, but the factor four implications are different. Factor four is market effect. This is an argument that has some legs. The argument that, because you're producing, like, photos are going in and different photos are coming out, they're potentially a substitute. There could be a market effect. The problem with that argument is that's also exactly what was happening in the reverse engineering cases. And copyright is generally structured to say, we kind of want you to learn from and copy unprotectable facts and ideas, and then go and add new expression. That's the general structure of how copyright works. So I think even that argument is a tough sell. I think the very best arguments, they're not amenable to a class of millions. They're much more focused. So a good focused argument is, OpenAI, you bypassed the market for access to ebooks and went to this site of known infringement, Library Genesis. And that undermines the incentives that copyright is meant to create. Like, I'm not saying I personally agree with that argument. I don't disagree with it either. I think it's quite a credible argument. And I think that's something that, the courts will have to decide. But, that doesn't get you millions. That gets you, a class of a few 100,000.
Right. So on that then, talking about the courts, can we just talk a little bit about, how this is going to be resolved in terms of, the law of which jurisdiction is going to resolve this? Is it really, based on your presentation, the law of where the model is trained, that really you can fairly safely ignore the fact that users are, causing inference to occur all around the world in many different jurisdictions, is it basically going to be decided, in US law on the basis that that's where most of the models are trained?
Yeah. US law, Israeli law, Japanese law, Singaporean law. I think they've just adopted a fair use doctrine in South Korea, so maybe South Korean law. Anywhere but Australian law. But with one complication. Like, if it's truly a non-expressive use, if the model has not copied the training data and is not spitting out copies of the training data, then once the model is trained, then there is no more copyright relevant activity. And so you can train the model in California and you can ship it to Sydney, and then you can run it in Sydney and do all your inference there, and there's no infringement in Australia. If the model, Stable Diffusion, for example. Stable Diffusion has a copy of Snoopy inside, there's no doubt. So if you're producing your Snoopy images in Sydney based on Stable Diffusion, then yeah, the person running the model in Sydney might be infringing that copyright. And if I understand Australian copyright law correctly, it's arguable that Stability AI is also jointly making that infringement, and therefore they could be liable. But by and large, this issue is global in a couple of important ways. It's global in that every country believes that there's a difference between idea and expression. In the US, that cashes out in terms of the fair use doctrine. In Europe, they have a specific text mining directive. But finding some way to accommodate this technology is something that I think all jurisdictions really should do. And even if you don't agree with that, it's pragmatically something that all jurisdictions need to do. Because if the models will be built, it's really just a question of, do you want the opportunity to have them built here?
Well, let's talk about that. I think that's a really key point. So as you say, what we have in Australia, we don't have a broad fair use exception. We have fair dealing, and that's for a number of specific things. And one of which is fair dealing for the purposes of research or study. And so there is some possibility that you can kind of see the case where there's research going on here, in that there's a kind of a systematic inquiry into the training data to discover new information about it. But it also has to be fair, and it also has to be pure research. And so where it's done for commercial purposes, I think that becomes a lot more challenging. So it might be, say, that academia maybe is in not a bad position for pure research, but many others maybe have more difficulty because we don't have this sort of broad-based fair use, right? And that kind of brings up a practice, I suppose, that was happening a little bit more perhaps in the early days, which is sort of called IP laundering, where the AI companies were getting academia to train their models on the basis that was more likely to fit within the copyright exceptions, and then using the models, as you say, once they'd been trained. Do you know, is that still going on? Do you think that was valid, likely to be, to work?
Yeah, I mean, the practice of data laundering is an interesting one. I think that under American law, by and large, the commercial, non-commercial distinction, it rarely does much work. Like, maybe it does a little bit of work in Factor 4. The problem with a sort of broad non-commercial exception and then nothing in the commercial sector is you get exactly this phenomenon. So if you look at Stable Diffusion is trained on a data set that was collected by Leon, which is based in Germany, I think, and it's within the parameters of their non-commercial text and data mining exception. That doesn't inherently make what Stable Diffusion did fair use, but it does mean that it's going to be very difficult to sue Leon because clearly they were non-infringing where they were acting. I think most of the large language models, you don't see that. Like, they do all the collection of training data themselves.
It's probably got too big now to operate on that basis. Yeah.
And I mean, the amount of compute that is required is like, my university colleagues would love to have access to that level of compute. But yeah, I think, I would be worried about a text data mining and machine learning exception that didn't have something to calibrate it to fairness or market impact. Because, even non-commercial, things that start non-commercial can still have a significant commercial impact.
Well, I think that really brings us to the absolute key issue for us all really here in Australia is what should we do? We've talked about the limitations of fair dealing for really general purpose generative AI. It's not really practical to go out and clear the rights, with a vast amount of training data. So what do? We have to change the law, don't we, if we're going to have that sort of industry in Australia? And so what advice would you give to Australia for the type of law that it should have?
Yeah, so I will start by telling you what some of my US-based colleagues say, which is like, oh, I don't care if Australia doesn't get a fair use doctrine. That's just good for us. So yeah, let that sink in. Honestly, Australia should adopt a fair use doctrine or a fair dealing doctrine that is not limited to specific prescribed purposes. But we've been down this road before. Like, I gave a lecture on this in Canberra in 2013, and by then I think we'd had like 2 or 3 policy rounds of discussion, and I know we've had many since. You should adopt a fair use doctrine, I just don't believe you will. So let's move on. Option number 2, fair dealing for non-expressive use, I think would be a pretty easy statutory fix. And, it would, you'd have like US cases for courts to refer to. You'd have many excellent law review articles by me that courts could refer to. And, that would work. I think you could model something on the EU Article 3 and Article 4, which are by no means perfect, but they're so much better than nothing. And so that would be an option. I think you could create a system of safe harbors with a sort of pre-registration where companies and researchers were required to do more than self-certify, but actually say, here are the risks we've identified and here's how we plan to address them. I like this idea the most, even though it's a little bit bureaucratic and centralized, because there's more than copyright issues. There's trademark issues, there's privacy rights issues, there's right of publicity issues, there's let's not make a tool that is going to be jerks to people issues. Not really a legal concept, but, it would sort of harmonize the copyright debate with broader concerns about AI safety and fairness. So that could work, right? I'm so far from wedded to, oh, you must do this. It's like, but you must do something, right? Because if you do nothing, this is all happening anyway. It's just going to happen somewhere else. And then you're just going to be consumers of this technology.
think, isn't the issue, in a way, it's broader, isn't it, than just for the AI companies? Because, and as you know, it's possible to fine-tune models by adding additional data. And so I imagine that some of those issues come up in the fine-tuning process too. If you want to access another data source for fine-tuning a model, you would also need to overcome the copyright issues in accessing that data source.
Yeah, yeah. I mean, if you want to, like, literally, there are important technical differences between fine-tuning and model training to begin with, but in some sort of broader way, they're kind of fungible. Like you can add abilities to a model through fine-tuning. And yeah, so that development at the moment, other than for pure research, can't happen here either. So, I had lunch with an AI developer in Atlanta the other day who has basically a plugin that you can add to Stable Diffusion where you can give it 20 reference works and then it will produce art in that style across a whole range of subject matters that aren't in the reference works. So, there's a really interesting question of, given that these are so tightly shaped by the reference works, are the new outputs derivative works based on the reference works? I think they might well be. But it's it's a cool piece of technology that's going to make some graphic artists incredibly productive. And that would be totally illegal here.
All right, on that cheery note, I might throw it open to the floor. Would anyone like to go first and ask a question to Matthew? We have a mic. Thanks, Natasha.